Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts to the show. Myself, Todd Ryan, Jeff Neuman, and David Michaels. We start off by saying hi to my co-host, so I'll start off by saying, hello, Jeff. How's everything going over there? Yeah, do your best, but yeah, I can hear it rumbling around out there. Well, David, how's everything in Toronto? What's up? Well, we appreciate everybody being here. As you know, if you've joined us before, this is the Domain Name Law Show. We talk about usually domain name legal news, and then we'll review some UDRP decisions. If you want to follow along, you can go to dnlshow.com or slash outline, or you can just go to dnlshow.com and you can click on there where there's a link that says outline. Um, Sort of follow along a little bit. Today, the very first thing I didn't have on the outline, but I did want to check in with Jeff. I know he was handling a case. I don't know what he can mention about it, but I know you were in Arizona last week for something you're working on. Is there anything you can mention? Is it domain related? And is there anything you can share with us? Okay, we'll jump right into a lawsuit that is happening, or basically it's been going on for a long time. And David, I didn't check out the links that you provided on X, and I sure wish I would have. I was getting ready before the show, but it's about Rob Monster, and I'll just say quickly, we all know that Epic went out of business. That was the registrar, and they're back in business as Epic under new ownership. But when Rob Monster was running it, there was all sorts of issues with this magic coin, or I forget what he even called it now. Who cares? But what was that called, David? That token? You remember that token? Yeah, I almost forget. We've said it so many times here, but anyway, so Rob was just there was a judgment against him for $349,000 that recently was published, and that included this $300 that he owed a guy plus 27 well 327,000 that he had stolen, I guess, plus some interest. But David, tell us a little bit about that judgment out of Washington that's against Rob and his wife. Just one of the issues that, okay, so we're talking about, if you just joined us, we're talking about the judgment against Rob Monster, who used to run Epic. Okay, so David mentioned that he tried to settle with the guy and said, "Here's a promissory note for 100,000." He didn't follow through on that, so the guy ended up getting a judgment for the full amount, plus I think the 100,000. I don't know, but the point was the guy bought this Nourish.com for 300 grand, and he paid 300 grand to the domain owner through Rob, and then 27,000 to Epic for the transaction for commission, and no domain was delivered. And of course, the domain owner, I don't even know who that was, probably kept ownership of it unless Rob robbed him as well. But so basically, that money was just, like David said, passed out to whoever Rob owed money to, or however he wanted to spend it. But no domain was delivered, so that money for the name and that commission was lost, and now this guy got a judgment to get it back. And he had, anyway, he's just one of many that Rob owed money to, Epic owed money to, and now obviously the wheels are falling off, and that's what basically this case was. We're just watching that. Okay, so somebody sticks with it, they get judgments against someone, and now we're seeing, all right, how do they collect on these judgments? So maybe we'll find out in the future, how are they going to collect on these judgments? And I want to ask you both, Jeff and David, when a court has a judgment like this, can a person include these judgments in a bankruptcy? I just asked AI how many judgments it says. Your guess is as good as mine. No, could you imagine? Hey, I'd like to see names compost. Rob's going to be speaking at this. I'm not. One thing that's not funny is the people that he owes money to, and there's from small investors to people that owe looks like six figures and some even seven. But to me, I don't know. Like I said, every conversation that I had with him, and then seeing him on Zoom calls and stuff, it was never a question in my mind that sometimes. I mean, I don't see how people can't sniff out crooks. Sniff you when you're talking with people, and what I mean is, it always seemed fishy. But then, let me see who's requested to come up here. Oh, Gabe. I was thought it might be Arif saying, yeah, but his platform was good. I know. The point is, I mean, to me, you can, when I'm talking with certain guys, and in the business now, you can tell who I think is fishy or up to stuff. And that's some guys that may be running parking companies now, or guys that, not mentioning any names, but are vendors or run registries. The bottom line is some people that you might feel, I mean, I just get a vibe, and then I don't do business with them, and then we'll see later on if in fact it was correct. Except Rob just, I saw him on a Zoom. I bring it up, talking. He's got all sorts of problems, and he's like, "Does anybody on here know any good lawyers that could?" He's asking. It was just anyway. There was all sorts of red flags with that guy, especially all the international folks that said he let us transfer money basically to, he was doing, helping them do all their personal, all sorts of personal banking. When it works for you, fantastic, until finally all this shit falls apart. And then if you're not stuck holding the bag, I don't like when someone says, well, he always treated me good. Yeah, I know guys that were, I'll say, anyway, terrible guys. They never did anything to me, but that doesn't make it like, hey, so no, I'm cool with him. I didn't mind what he did to your sister. All right. Hey, Gabe, what's up? How's everything going? Good question. I'll let the lawyers answer and then I'll say my 2 cents. But go ahead, Jeff. So, Gabe, for example, and I bring this up quite a bit, Tony's Pizza, they have rights in Trenton, New Jersey, let's say. Well, someone in Fort Lauderdale can also have a Tony's Pizza. If especially, well, like Jeff said, if they only have common law rights, then of course it's geographic. So where do you do business? Where are you known? And then sometimes they try to expand those areas by saying, well, we do business in other places. We advertise all over. So sometimes our business is well known outside of our, where we're located. But as Jeff mentioned, if somebody got Tony's Pizza as a USPTO, as a registered trademark, there's still going to be limitations because of senior users or people using that exact mark in other geographic areas. So it really depends. But Jeff, this case was, I think, Gibberlink. Is that Gibberlink? Okay, so it's somewhat of it seems like a made up word, but it's actually a phrase that's used in the space. I mean, what is it? Give us the general description again. Go ahead, Dave.
And okay, I see. I've never heard this, but that's not a surprise. Um, and who's claiming to be the owner, or who's the trademark owner?
It's one of the developers.
Boris
There's two devs.
Starkov.
Exactly. Yeah, he's one. He's one. He's the one that's filed the complaint. Yeah, and
Is that,
they're both hackathon winners of the open source project. And at the time, there wasn't a trademark. He registered the trademark. It was like weeks after they announced the winners of the hackathon. And in my case, I'm proving that it's not in bad faith. The landing or the website that I had was I had a disclaimer on there that said it wasn't affiliated with the the actual project or the owners, and that it was more of a community page that had all links going back to the repo and the open source project. There was a button on there that did have the domain for sale, but as a domain investor, that's normal practice for I would say domain investors when you have traffic. The traffic was in this like 600,000 events in 30 days. They kind of went viral, and so that was how I based my price on selling the domain.
So the domain was registered about a week before the trademark application was filed by Boris.
Correct. Yeah.
Um, there was somebody else who filed an application in South Korea, and that date of filing is March. It's
I
actually the application is March 15th. So interesting. I got the dates priorities wrong.
So it wasn't in bad faith. I mean, and it wasn't trying to sell to the trademark owners. I think that's kind of where.
Well, hold on for a second. And Jeff, I wanted to say I'm muting you when you weren't speaking only because of background noise. But I want to say you're you're not the panelist here, Gabe. Okay, so I'm going to play devil's advocate. So you're saying all this trying to persuade, but I'm going to ask Jeff because he is a panelist. But if I was the panelist, I would be asking, don't tell me what's in bad faith. I decide that. Okay. So what I would want to know is what why did you register the name? What were you planning on doing with it? What actions have you taken to put that into action? And you can't, you don't want to throw all the shit at the wall. You might have already done that in your reply, meaning that it's generic. I got it for this reason. I was going to sell it. I'm also doing this. I mean, I always tell you, panelists don't like to hear all the different stuff, but I was going to say first, let us know how you answered those questions in your response, and then Jeff, I'll let you chime in of what a panelist would like to see. So first, Gabe, when the panelist wants to know, so why did you register this name? What instigated you
you know
to register the name, and then what were your plans for it, and what actions have you taken to implement those plans?
Correct. So I do understand what you are saying, but in my response, it was more just rebuting the rebuttal to what he was the complaint was about, which was that I was using it in bad faith, and that I uh, tried to sell it after the trademark. So I had to prove that that was not true. But to answer your question, um, what did I do, or what was I doing? It was a community page um, about the project with links to the project. And as I seen the traffic coming in, I decided, well, this domain, I could put it for sale, and and that's what I did
So your
based
plan
on the
was to have a
traffic.
community page. It was because still they're thinking, okay, you're rebutting you're trying to rebut what they're claiming, but still the panelist is going to know. Okay, so you do that by saying what was your intention when you registered it, and if you're saying it was to have a community page on their project, okay, so it was going to be a non-commercial page to offer information. I mean, some kind of Discord or some kind of I have no idea. You
Well,
know,
that's what
Yeah,
Wikipedia shows. So sorry, archive.org shows that on February 28th, jitterlink.com had some content about this project involving 11 labs. And yeah, I think what you should do is also do some research on the Gibberlink background information, do some deep research and get the source documents about it being developed actually at Google spontaneously by AI back in 2017. So it's a known phenomena
well,
that
he's
was
already
done
answered.
before.
He's already answered now.
No,
So,
he hasn't. He says he's finalizing it. He hasn't finished
I
it.
thought you sent it in already.
no, no, you're correct, Todd. I did. I
Okay.
did. I finished it yesterday and I sent it through
Yeah.
um,
So he's not going to file a
because I was
supplement.
concerned. I tried to do it through the online form, and the button wasn't allowing me to submit it. So I was like thinking, oh man, this is not going to go through. So I ended up just doing an email with the attachments. Um, you can do either or.
This is the reason I asked Gabe too about what's included in your answer because we're going to end up we're going to see your decision and see maybe what helped you, what didn't
Well,
help you. But Jeff, yeah, go ahead. What would you have liked to have seen
why
as a
is it?
panelist?
But if I go to gibberlink.com now, it just takes me to a sale page.
Correct. So the the community page, I had a offer on the domain, and I had declined the offer. And after I had done that, I removed the website, and I just had a landing page from the registrar.
And so, but the issue is, so did you submit like evidence from archive.org of what was on the page?
I did, yeah, from the 20th I submitted a archive from the 20th, but it has snapshots up to, I believe, the 28th.
But what was submitted with the complaint?
I think it was the first snapshot of the community page.
Oh, so the complainant didn't submit what it is.
He submitted the now
Yeah.
the what it is showing right now, but not what it was showing in the beginning, which is what I had up um, for a few weeks, was just a community page talking about the open source project and all of the um, news that was happening. I think Tech Radar, some other
Did
news.
you explain why it now, I mean, you explained it to us, but did you explain in your response why the page now just says for sale?
I did. I put in there. Um, it's normal practice for a domain and through my portfolio that as domains become or have high traffic, I do, and I submitted the traffic data that then I decide to sell the domain. So that is a part of the annexes, I believe it is, or the screenshots.
Yeah,
Well,
it's
next
gonna,
time, actually hire somebody. I think you need more. Maybe
He
get
already
some
sent it
assistance.
in, Dave. So he already sent it in, David. So unless the panelists ask for a supplement, they could always send in a supplement if you wanted to. Not that they're going to look at it, Gabe, as you're
Yeah.
thinking more of stuff. You can say, "Oh, here's a supplement," and you would want to do that quick. Jeff knows usually supplements aren't allowed unless they request it, so you can't just keep adding stuff in there. But Jeff, in when you say Gabe, when you say it's only normal for that. When you say that, that's just you're just saying stuff. What you have to do is you have to show, okay, other domain investors. It's a practice in our community that when there's traffic, and you have to supply evidence of that, and those are the annexes. And you probably didn't do that. You're just stating a bunch of stuff, and sometimes the panelists will receive it. Okay, like yeah, I just had a case,
Yeah.
and it is true that and I'm glad you submitted some traffic to show that's why. But like I said, and I'm just playing devil's advocate here, that the panelist thinks, all right, so if I do believe that you saw that they had were spouting this out publicly, and then they you wanted to jump in front of them before they filed their application for a trademark, so you were anticipating them filing, and you registered this name. Okay, then we want to really understand as a panelist what why tell us more. Why is this? Why would this be considered generic? So you need to have a lot of information in there. You want to load it up. If you had a lawyer on your side, they load up why this would have been a generic term, and then also all other senior users, like David was talking about, two other people that have used it way back, and just all different other uses. Did you include anything about other people using it, other examples of usage in your response?
I did cite that it uses it uses GG Wave, which is the I guess the repo, the GitHub repo. It was already built, so they used that repo to then build Gibberlink. So I think that was the only
GG
citation.
Wave is a C library that was made in 2019 by some other engineer
Yeah.
and
so I think
used for this type of.
look, it's going to be a close call because, but one thing I would advise moving forward with names is like your first site was good, right? Like that puts things up in a very non-commercial way. Um, yeah, you kind of have the domain for sale up on the top right, but you can see what it is describing um, Gibberlink, although I still would prefer it not say domain for sale. But certainly the second, the once you put it on the registrar page where the sale is so front and center, I mean, I think you didn't help yourself by switching over to that. I would, in the future, stick with your general page and not change it over because panelists aren't going to understand what you explained to me, which is, once you find enough traffic, you think it's now marketable and you really want to, kind of show it's for sale. Um, Panelists aren't going to see it that way,
I
likely.
understand. Yeah, I understand. This is definitely a learning experience for me. This is my first UDRP, and kind of gathering the facts and the information to create the response has been, um, and I would say, good, because it gives me uh, the insight to how or what I should have done or should be doing. Going forward, I have another domain that's an open source project that isn't trademarked, so that's kind of I've tried to invest in domains around that niche. It hasn't been really successful for me. Um, and the other open source project is also a Microsoft, uh, I guess their lab. Um, they have a lab where they create different things. And anyway, I thought, well, maybe this is invest it's something that I can invest in and create these community pages about the projects if they're not trademarked. That's kind of how I came up with doing the Gibberlink one.
Well, you could create community pages for any kind of research, even if it's trademarked. The part where it gets dicey is the domain for sale. So
Yeah.
if your goal is just do community pages, great, right? If
Now,
your goal is to sell the name,
yeah,
that's
yeah,
when
but
it kind of crosses.
wouldn't it be, or is it wrong if you only try to sell it to the trademark owner? If I'm just selling it in general, which I was doing, because I know there's value in the domain, with as in the traffic and as being an open source project, is there any difference in doing that versus selling it directly to the trademark owner?
Yeah, so technically the UDRP also looks at whether you sell it to a competitor or if the price that you're charging is really dependent on the goodwill of the trademark owner. In other words, if Gibberlink would have the value would be, $1 if, and I'm exaggerating here, if there was no trademark owner, but because there's a trademark owner, now the value is 45,000, which is what you have it here. That's a problem under the UDRP as well, right? If the value is of the name is derived independently of the trademark owner, you're good. But if the value is derived because of the trademark owner, that's where you kind of run into issues,
I see. And in
right?
this
So,
case, yeah,
yeah. So, like if you add Google.com, right? In theory, let's pretend the real Google had something else, right? In theory, Google.com as a domain name, independent and apart from the trademark owner, would be worth a ton less than Google.com now because of the trademark owner. Because Google is a word that's in the dictionary.
I see.
But if you're selling it for $10 billion,
Yeah.
then they're going to know,
Well,
well, the only reason you're doing that is because the trademark owner made that term valuable. So you're making money off of the trademark owner.
okay. So regardless of the traffic, it's not like it's value because of the traffic. It's value the traffic in essence because of the trademark owner. In this case, the traffic doesn't have anything to do with it.
Yeah, that's what their complainant's argument essentially is.
Okay. Okay, it makes sense. Yeah. I mean, at the end, if it's something that I end up where I do have to turn over the domain. Hey, I learned something here. No hard feelings, and I move on.
Gabe, thanks
And
for
that was a hand. Wait,
yeah.
hold on one. And that was a hand registration. That wasn't bought
Yeah,
from.
It was a
Oh,
hand
yeah.
registration.
Well, so not too much investment there.
Correct.
Gabe, first of all, thanks for sharing all this, and it's a good name, and that's why a lot of listeners are thinking, "Hey, I would have known not to do this." I mean, I know what I can do because they've been around for a while with domain names, and Gibberlink for a hand registration sounds great, and it sounds like a cool name. There's value because now people are using it, but as David mentioned, looks like there were at least a couple, two or three different people that have used it in the past. So one, that's why the UDRP is good for domain investors because you certainly didn't want to get an ACPA, a court case, an action against you, because then you got to really have a response in federal court. And believe me, if you don't know the procedures, you're going to need a lawyer there. And plus, you could be penalized up to $100,000. So this one is like, geez, are you kidding? I'm losing a pretty good name. I think is cool, but it definitely can be a learning experience. But the truth is, this name, what a cool name. If you would have slowed things down, like Jeff said, then you're still going to get UDRPs, and I'm talking to everyone now on a name you registered, uh, 20 years ago. My partner is going through one right now. We haven't got the decision yet for ksuite.com. He had this name 20 years before the trademark owner used it legitimate reason. I mean, basically, so many things on his side, including they made an offer but didn't want to buy the name. So there were just several reasons why we feel this was an RDNH, or reverse domain name hijacking, like a really abuse of the system when they filed that case. The point is, you're going to have complainants that file when they have no ground to stand on, but definitely when they believe that you registered the name with them in mind. It's okay to know about a trademark and register a name. If you know about the mark, it's is your intention to sell it to that company. And like you made it clear, and this is for everyone. Again, when you're offering a name for sale, if you can on that for sale page, it would be like an email that you're sending out to say, this could benefit anyone who wants to, have a repository on this, or anybody that wants to have a community on this, or anyone that wants to do. You want to show that it can be a good fit for quite a few people, not just one person. And Jeff made a great point about, there was a case, converse.io, I believe it was converse dot something, but the panelists said the only reason you're offering up for $250,000 is because of Converse, the company, and they ruled against the domain owner and transferred the name. But yet we know people converse with each other all day, and Converse is really a much more used word by a lot of different people than just that brand. But if you're pricing it at a certain price and there's only one, new user, new mark holder, and there's like maybe one in the past, like David was mentioning, that really is not much around anymore, you have to consider all these things. But I'll finish by saying, Gabe, thanks for sharing your experience. We want to see really what happens. There is a chance that the panelist does a little bit of research from what you've given him, and and what the complainant, I don't know all the evidence that they provided, but the panelist may do some research and realize, maybe a Star Wars fan, and think, I know what gibberlink means, that you do have a little bit of right there, and maybe, so I'm not going to say a coin flip. I think it's the timing that is negative for you, and that is they think, okay, so this person announced something, and then the name was registered. Before we move on, I want to mention a similar thing. There was on Shark Tank one time when there was a company say, we got this product called Float Baby. I can't remember the product now. I think it helped babies from drowning, but the thing is, it was called Float Baby, and they're on Shark Tank. Float Baby, Float Baby, Float Baby, and I'm like, their domain name, I checked it, was floatbabies.com, and I registered Float Baby. I registered right then. Well, I ended up selling it to him for, I think, 1,500, 2,500, maybe 3,500. I got it somewhere. But I was lucky they reached out and thought, damn, we want the name. But they certainly could have filed. I would have slowed things down and tried to have a good response. But that is really an unusual name. And then, of course, in a UDRP is not like a court case where they go, hold on, we're going to check what date did he do it? They were on, we checked his viewing records through his television provider, and yes, he watched that Shark Tank, and yes, he did register it right then, and but not never. I only put a price on it and never reached out to them. They reached out, but the point is, you as domainers, we do that all the time. It's better to do it on generic stuff, but you're going to see people with products, and you're going to realize, well, that's their main product, and that's what they're talking about, but it's a generic term, spandex shorts or whatever. And you may, so we do have a lot of rights, and you even had some rights you do with that gibber link. So you have rights with it. It's just now whether you did a good job explaining your case, but we'll see. So Gabe, thanks for jumping on stage, and also keep us informed as things go on. We'll be here. We wanted to get to our cases. The first case really was part of our news, so it's not a long case, but I thought you guys would find it interesting. It is a domain ruckus1, ruckus.one. So this domain owner owned ruckus, purchased ruckus1, and let me go to my outline. What a beautiful outline I set up for today. That's at dnlshow.com/outline. Okay, so this complainant in this case, Ruckus IP Holdings, and I didn't even really take a look at what they do, Ruckus IP Holdings. Well, David, I know you looked at this case. I could, it's really simple, but tell us what happened here. It's not one of the ones we reviewed in depth, but there was not much to it. Tell us a little bit about what happened here.
So ruckus is a common dictionary term. The panelist did note that in her decision. It's registered in 107 TLDs. But for some odd reason, this nurse out of Texas decided to say, okay, well, I'm going to agree and I'm not going to object to, this UDRP complaint. They can have it. That was the mistake, because I think the panelist was going to rule the other way if she hadn't done that. The nurse had just said, hey, I bought this because I got 2 kids who are always causing a ruckus. I'm a nurse and whatever, right? That would have been, there's nothing on the website that was untoward towards that particular plaintiff or complainant. It's active in 363 TLDs. The word ruckus is in 1,959 domain names. It's just like a stupid UDRP complaint that they filed for no apparent reason. Are they going to go after all the other 100 ones that they don't have already? I don't know.
Yeah, in this news article, basically, so it was basic. The person responds, the domain owner, I registered it because it was your generic name. In ruckus, but I'll give it up if you want. It's sort of like David said. So didn't even need to say that. May have swung in their favor. I do see that that ruckus.one is got a GoDaddy buy now 2,488. So that's confusing to me because I know that wouldn't be the winner. That probably hasn't transferred yet. So unless this person was just, I don't know, are they full of baloney? They can still own ruckus. It's like you said, it's registered in so many different things. But does a nurse in Texas? I got kids, and my kids love GoDaddy, and they're also both domain investors. And I'm on Afternic anyway. So it looks like this was a domain investor. I don't know. Anytime I see a buy now price with the GoDaddy lander, but yeah, Jeff, do you think? If you got a case and this person did not respond at all, and you had a case where you went there and it's like it is, that's a landing page for 2,488. I know you'd need to know the complaint and all the evidence that they supplied, but ruckus.one, ruckus, such a generic word, and there's only a for sale lander. What's your?
The complaint would have to show targeting, and have to make the case of targeting. It's with a word like that that's got a common meaning. If they don't show the targeting, and of course I would go to the website, um, then they would not prevail. The complainant wouldn't prevail. So I just think that the registrant for this was just like, you know what, not worth it. I only paid whatever from the .1 registry. It might have been on sale for like $1. Who knows? Um, so I understand why people just don't want to fight it, and um, they just don't want to deal with it.
Yeah, but they did. I was going to say, yeah, but they did fight it. They did say it's like it's not worth it. You already said it. You already said I bought it because it was generic. Just stop there. Just don't say anymore. I mean, and you still may lose, but um, you're not. There's no more fighting to it. It's like I don't want it now. If they thought, geez, I do want to give it up because I'm so afraid of a potential,
But
court
it's
case after
also
this.
possible
Yeah,
that there was communication behind the scenes we don't know about, where the registrant said, "Hey, look, I'll just give this to you. Can you give me a year's subscription?" Or well, I don't know. Who knows what there could have been behind the scenes? Like it may not just been that they gave up. It may have been there was some incentive for them to give up.
correct. I mean, and I did that before. One time, tell you about a case. Epidiolex was the name of a drug by this company, GW Pharmaceutical. It had some kind of, something from some THC in it, I believe. But it was a same company who I think did Marinol, but maybe I'm wrong there. But anyway, they came out with this drug Epidiolex. Okay, and oh, I know they tried to get a name from me that I owned way before that they had a product called Sativa X. But I called it Sativex, but they wanted to get a name from me. I can't remember, but they ended up not pursuing it. I think because maybe I scared them off with my responses because there wasn't anything filed on it. But anyway, I was really upset with them, and I thought they just pissed me off. So I registered Epidolex because I knew that's how people were probably spelling their drug that they came out with, Epidiolex. And I thought I'll just get Epidolex, and basically that was pure targeting. Okay, they filed a UDRP against me. This was 10, 11 years ago, and I immediately reached out to him and said, don't need to do this. I'll, just give me the money back that I spent on this name, $450, which of course you guys know it was $10. And we'll, you can withdraw your complaint. You'll get your money back. And I thought they got back the whole amount. I guess they might have only got back 1,000. I forget how it works now, but because
So
what is it? How much do they get? Do you know? Want to say something, David? Um, I thought they got the full filing fee back if you do it like within 3 days. Maybe it's within 5 days. But so that could have happened in this case. Somebody could have said, "Hey, you don't need to do this. Just give me a few $100 and I'll go ahead and." But
I think it
usually,
depends where you file it, because I think I don't believe the forum offers any kind of refund.
good point. And there's 6 places that you can file these UDRPs around the world. We always talk about WIPO, World Intellectual Property Organization, because they handle the majority of them. And then Jeff mentioned the forum. They handle the second most amount. And then, of course, there's the Canadian place. There's a place in Serbia. There's one in China, I believe, still. But anyway, so 6 of these service providers have this deal with ICANN that are approved by ICANN that people file a UDRP complaint. And right, they all have, WIPO's $1,500 to file. And then if you request a 3-member panel if you request it as the complainant, which that seldom happens, but sometimes they'll do that, then it's $4,000, and so it's $1,500 for one, $4,000 for a 3-member panel, and if you're the complainant, then you just pay the full amount. If you're a complainant, you file, and it's $1,500, and then the respondent says, "I want a 3-member panel," it's going to increase to $4,000 total, but then the respondent pays $2,000 and the complainant adds in another $500. So then it's split down the middle. But anyway, there's I think is the form 1,500, Jeff, or is it like 1,200 to file? What's the cost of filing for someone to perform?
Yeah, it's less than 1,500, but it's like 13 or 14 something. I'm not sure exactly because I never pay attention to that.
Yeah, I mean, and then I think in Canada it's like 1,100 or 1,200, maybe a grand. But anyway, so there's 6 different places you guys always want to know, and I know you don't always want to know. All right, we're going to get to our first case. So that was just a piece of news that ruckus.one. Somebody, there's probably more to the story, but they said I registered because it was generic, but you can have it. Oh, geez, don't just anyway. Many times in the old days it was don't answer and you may be okay. With the UDRP, that is really seldom the case. Some things you can do is always say, and I would have, mentioned this to Gabe, to anyone, you get one thing you can do if you did not register the name in bad faith targeting that particular trademark owner, you can always include in your response under penalty of perjury, I state that I did not register this name in bad faith to target the complainant and to sell this name to the complainant. And you certainly can say, if you didn't know about them, be sure to bring that up, that I wasn't even aware of them. But as I mentioned too earlier, you can be aware of somebody that owns a trademark before but as long as you're not targeting them, you're still in the clear. And and really you have rights to even if you're using it in a non-commercial way, even if you can own brucespringsteen.com. I mean, you can own um, coca-cola.com. That's a tough one, but if you're not doing something commercial and you have a legit use that you're using it for, you can really just flat out own somebody else's mark. And then, of course, we're going to talk about this very first case, mit.mortgage. We brought it up last week. So mit.mortgage is the domain name. So this is, of course, a new GTLD. MIT, the school, Massachusetts Institute of Technology, filed this against this Kevin Hanlon. He's out of Rhode Island. But, of course, MIT's on mit.edu. Interesting about this case, both the complainant and the respondent have attorneys, right? So you would think this respondent, I really was hoping for a more solid answer out of this respondent since he had a lawyer. But if you hire a lawyer for a UDRP dispute, if the domain name dispute, if they don't know domain names and domain name disputes, lawyers usually are specialists, in a few areas, not all areas. So that's why we always say, get somebody who understands domain name law. Otherwise, you're paying. And in this case, I thought the respondent had a good case, but I'm going to give it away and say that he didn't have a great response. And that's according to Francine Tan, who's the panelist, the single member panelist in this case. But a few more facts, and then I'll throw it to Jeff, because then I know David has plenty to say on this. Anyway, so just a couple facts that this domain name resolved to a page that had a look-alike logo, and that's what sort of bothered the complainant. Now, the complainant sent a respondent a note, and the respondent removed the logo and said, "Hey, sorry, that was made by a third party, and so sorry about that. We immediately took it off," and that was part of their response that they thought would help them, in the winning this case. The phone number on the website belonged to this company, applicationleads.com. So it appeared to be a site where they were getting leads for mortgages and then sending them to this company, applicationleads.com, which plays a role in the decision as well, because it was the lead gen service. And then this respondent that I mentioned, Kevin Hamlin, he had his address on it. Well, now there's a lot more facts to the case. David, tell us about how the respondent, what he claimed in this case. Sorry,
Well, he has a business called Mortgage um, Information Technologies. Before, he used to be an LLC, and then last year he incorporated as an Inc. in Delaware. And the panelists didn't care about that, and that it was like MIT is just an acronym of his business name, which is a really long business name, which is a common practice. Now, this panelist is a INTA stalwart who's based in Singapore and prides herself acting on behalf of the trademark community and prides herself about her INTA awards and so forth. She shouldn't be a panelist. In her last 100 decisions, she's only denied one. Only one. She's as bad as Dawn Osborne now. It's just bad. And I'm like, you can just pick through her decision list and find ones that you don't like. Last year, the ICA talked about the app science dot, I think AI case or something like that. And app science is like application science. It's a field of study in university, but that was a transfer. So she is somebody who is mistransfer and she will transfer anything. So that is a problem. Now, this lawyer who represented the respondent, he does DUIs, criminal offenses, and stuff like that. No mention of any type of business law experience on his website. Definitely not UDRP law. So
Well, David,
those are the big.
I'm sorry to cut you off there, David, but I wanted to say and get Jeff's take on this because you think it was a this. I didn't know her past record that she's definitely, and a lot of these panelists are pro mark holders, meaning they represent big companies more than they represent domain owners, usually in their history or their experience of practicing law. So they just always lean towards the mark holder. But Jeff, in this case, I think she did make some good points, and I'm talking about the panelists saying that the respondent was making claims that he couldn't back up. He didn't use mortgage
Yeah, I mean
information
that's
services on the
right.
site. So,
That's the big thing about this case, and even like some of the other case, or at least one of the other cases that we're going to look at, is if you're going to make a claim, like you're commonly known as something, or that you've been using something, or that you've been operating since January 2016, you got to show it. You got to provide some evidence. And oops, sorry, someone was calling and I got disconnected. You guys can still hear me, right?
yes.
Cool. Yeah, so when you make these kinds of claims, you have to show it. You can't just make the claim. You can't, like in this case, the respondent claims that they were established in business since 2016, but then they only showed the registration of 2024. There was the problem with this link, and they say, well, the logo was put on by a third party developer and not by them, but they didn't provide any evidence of that. So, and there's also, MIT does, and I'm assuming they showed this or the complainant showed this, but, they do um, have projects that are related to real estate and, and mortgages. And so MIT, it's not just an educational institution, but where does it say? Complainants also involved with and associated with matters relating to mortgages provided to MIT members and others, real estate finance and mortgage, securitization, credit, and lending classes since at least 1940. So that's part of the services they do offer, and they show that. Then yeah, I mean, don't just think of MIT as the educational institution, but the main thing here is the credibility of the respondent and the response that it filed and the claims that it makes. And if you're not going to support it, you're going to lose whatever credibility. You could say whatever the hell you want in a response. And in fact, I think the next case, maybe they do. But if you can't show it, then there's not much. Um, there's not much that the registrant can do or the panelists could do in terms of ruling for the registrant. So I think this case was rightly decided, um, but I understand David's view as well. But I think this was the right thing.
Yeah,
Yeah.
David.
So some more facts. We have 141,000 domain names that start with the words or the letters MIT. It's registered in MIT is registered in 209 TLDs. So I don't think that they're actually known for their mortgages. Is that something that's just internal at MIT? Because I've never seen them advertise for it. And even if it was, and say that if this is a fact which they didn't bring up in the decision, but if he was actually a third-party broker for MIT mortgages that like MIT is actually funding, well, then it would have been nominative fair use. So we don't know these facts, but it'd be interesting. Next time you get a UDRP complaint, hire an expert to do the research, and then hire a UDRP lawyer who's an expert at filing responses.
Well, in this case, mit.mortgage is the domain name. Jeff said it correctly that there was a nice complaint. Basically, they said, we understand where the school, but we also are involved in mortgages. Here's how. And they laid out their evidence. And then so that was the connection. So mit.mortgage. So they have really reason why. And the response that comes from this respondent, he basically just said, hey, I went to extreme lengths to avoid confusion. Number one, I registered a .mortgage. Well, then we see they already have made a good argument that they're involved in mortgages. But the respondent said, I registered this .mortgage. I used the full name, this mortgage information technologies, as opposed to using MIT. You never see I use MIT on the site, but yet I didn't really see the mortgage information technology being referred to either. But then the final thing the respondent said is, yeah, they asked me to remove this logo. And soon as they asked, I told them it was a third-party logo and I removed it. That's another thing that they didn't do, and that is show that here's who we've hired to do this logo. It was a third party. Here's what they returned to us. It wasn't our fault. So they just made a bunch of claims, and they didn't really provide any evidence to support them. So that's why I was surprised. They have a lawyer. Yeah, it's a drunk driving lawyer. They didn't have a great defense anyway, in my opinion, but they certainly could have, like I say, slow things down, have a solid, at least a more solid defense. And in this case, I think it really could have went either way if that person would have had a more solid defense and showed evidence of those claims that he made. And then it still probably would have been a coin flip. But yeah, when you have, basically just a better argument on the complainant side, crappy defense, and the panelist is like, geez, this one's stronger, just makes more sense on the complainant side, so I'm going to transfer. But then, yeah, David, I didn't know of all the certainly leans towards the complainants in most cases. So not only do you need to answer if, and you don't know who the panelist is before you answer, but if you get a panelist like this, you certainly need to have an answer, and you need to have a good one, because if you don't have an answer, I can imagine it's quick to transfer. Okay, so that's mit.mortgage. The domain owner lost it. It was transferred away. This next case, okay, this is more of a true, in my opinion, true cyber squatting case. Now, they could have slowed things down and possibly had a defense here, but the domain name is kfc.global. Okay, so I wanted to bring up some acronyms. And KFC, we all know KFC stands for, what's the same? Oh, Kentucky Fried Chicken. I was going to try to come up with something funny, and I couldn't, because it's just so ingrained that KFC, there's only one thing it stands for. But this domain, kfc.global, of course, the complainant was KFC, the corporation that owns the chicken parts place. and then the respondent, the domain owner, was Vinay Patel out of Maryland. And the reason why I said this is really a classic cyber squatting case is because, well, the main thing is this respondent's website had, KFC in red. It looks, I mean, if it's not the exact logo, sure, when I went to the website, kfc.global, it looked like the KFC logo to me. And they're trying to sell a token, some crypto coin, and they're saying it's KFC. But what really is, damaging is they have a page company. You click on company, and it has the executives at KFC Corp listed on their page, but yet,
worse yet,
yeah,
it's got you go to kfc.global, you see Colonel Sanders in the bucket. Like the token, the picture of the token is the Colonel Sanders bucket. It says KFC on it, same logo,
I didn't even
same everything.
didn't even get that far. By the way, well, I'll throw it to you, Jeff. They said it stands for Keen Future Capital, right?
Yeah,
It
right.
doesn't even make, but so they really they did have an answer here, but and they provided no evidence to support that it was Keen Future Capital. But for all those other reasons that you mentioned, this was, you think, pretty clear cut
Uh,
case of infringing.
well, it also says, when in our company, we believe in the transformative power of fried chicken, done the right way. Like, really?
So certainly an infringing case, which would be a court case, but so this was cyber squatting too. They could probably file a court case, try to get damages. But what do you think, David? This pretty easy. You're not mad at Jonathan Agman, who that's the panelist who
No,
transferred
I'm
this.
not mad at him. I guess that decision was correct in that result, but I wouldn't call it cyber squatting. I would call it straight up fraud. Like there is everything about this website is fraudulent. Like kfc.global has employees, photos, locations. Cop the copy is straight from the global.kfc.com website, as if they had an AI do it for them and the guy didn't even notice. But like everything he put in his response was totally contradicted by the actual website, which is astonishing that he would actually even bother responding. Either that or he didn't know. Like that's the only thing I can think of, because that is like right in your face. I'm looking at it.
Yeah.
It's there.
It was weird when you are going to, why wouldn't this have been a no response and then just a transfer? Instead, this guy responds, but the domain, of course, is locked by the time you respond. They don't let you make any changes to it. He doesn't address any of it like, I got your CEO there and your CTO and your CCO, COO, whatever they have. There's all these pictures of people. I don't want to address that or our token or the token with the chicken and the kernel, but we just want to say it stands for Keen Future
Or the
Capital.
fact that, under our history, you talk all about the history of Kentucky Fried Chicken and show Colonel Sanders and the humble beginnings in 1930, and then finger licking good. It's not even like, yeah, this is not even close.
Yeah, and another thing was the date of the registration, 5/1/25. So they just registered it 2 months ago. 2 months ago today. So that's another thing when we looked at, the MIT mortgage, at least that guy had it for 5 years. And we talk about other cases where people have had names for 15, 20 years and then they're coming after them. Like, so these next two cases, I think you're going to like, because these are domains that were registered 25 years ago. And then you see what types of companies will still pursue it. So I'm glad KFC was like, geez, you guys, people think that we're somehow involved with this meme coin, and the person just registered this name less than 2 months ago when they filed this case. This is the type of thing where I don't mind don't mind, of course, a mark holder. This is what the UDRP was made for. We're the mark holder, and even when it's acronyms like this, because somebody could have KFC, it could be, and with the C at the end, that could mean company, and it could be King Fortress Company out of wherever. If you certainly can use those three letters, but in this case, it was recent registration. They're infringing. They're basically cyber squatting, and KFC goes after them. So you don't that's sort of what the UDRP was made for these big companies to be able to, or these mark holders to be able to go after somebody without having to file a lawsuit, because you really be spending a lot of money in courts. Okay, this next case. So that was the second transfer of the day. mit.mortgage was a transfer. kfc.global was a transfer. So anybody that's picking up, I think I picked up ygf.ai because I thought it would be like your girlfriend or something, meaning AI. But if it, and that's not a popular acronym, but if you do pick up a popular acronym like NRA or NBA or MLB in another extension, you can have rights to it. Of course, you don't target those mark holders, but you can own IBM in another extension. So keep in mind, we just saw two examples of acronyms that the domain owner lost it, but you do have rights to those if you're not targeting. All right, beech18.com, and it's Beech. You heard me, Beech. Beech18.com. Well, this is old Textron Aviation. Jeff is familiar with them. And now David and I are, because they file so many cases. Textron Aviation out of Indiana, a lot of litigious people in the Hoosier State, versus Carl's Flying Service out of California. So Textron owns, they bought Beechcraft in 2014, 2015, that aircraft manufacturer. They also own, as Jeff knows, Lycombe Engines. They own really a couple different companies, but they're an aircraft, obviously an aviation company. Textron's the parent company, and they filed this complaint against Carl's Flying Service because there's a Model 18 of the Beechcraft, and that's why he claims he registered that name, because he says this guy said, "Geez, you can't believe it. I bought one of these Model 18s back in, I think, 2000, and I end up selling it in 2010. I lost all sorts of money. Now I'm in foreclosure." The guy started going on about some crazy response, and it wasn't any relation to the case, but basically he said, "I bought beech18.com way back. I've been using it since 2002. The registration shows 1999 in November." So that was confusing a little bit to the panelists, but the panelists said, "Okay, you've owned it for more than 20 years. Still, and you say it was for enthusiasts that own this Model 18 of this Beechcraft, yet Nick Smith, the sole panelist, didn't buy into, basically didn't like it. He felt like he was still offering other parts or other services on the website that competed with Textron's Beechcraft mark. And before he made his decision, he was really looking closely at that. I guess I don't want to give away the decision just yet. We've already had two transfers. Jeff, what say you about this case? And then Dave, go ahead and take it after that.
Yeah, so it's kind of weird because Nicholas Smith seems to confuse registration and use. Like he kind of examines them as if they're one element, which also is apparent on the mistake that he made, right? Or what you said earlier, Todd, where you said the panelists said in the decision that the domain was either registered in 1999, according to the Who Is, or 2002 when he said he was using it. No, it's registered when it's registered, right? And so the problem for me this case is, yeah, it's not currently being used. Um, it's not. There's no rights or legitimate interests in this name at this point in time, which is when you evaluate it, because it kind of fails the Oki data factors, so many of them, because he offers a bunch of other things. But the real question I have is whether it was registered in bad faith. And here, the registrant says that he registered it pursuant to some deal that deal eventually fell through, but he registered it because of that deal. And if that's true, then I'm not sure it's registration in bad faith. Certainly use in bad faith. It's not nominative fair use. But there's a question in my mind, at least, as to whether it was registered in bad faith. Because even if you're wrong when you register it, even if you register something um, with the idea for a business and you could show that, and it turns out that business fails or never took off, that doesn't mean it's bad faith. So the problem I have here is on the bad faith element, because the panel has found both registration in bad faith and use in bad faith, but seem to base it solely on the use in bad faith.
Well, it's worse than that. Nicholas butchered the decisions in New Kids on the Block and the Tabiri versus Toyota case. he should reread those decisions because they don't say what he says they say at all. You don't have to have exclusive use. It's up to the plaintiff in those cases to prove that there's not nominative fair use. So the onus is on the plaintiff, or in this case, in the UDRP, would be the complainant. And this Beach 18, okay, so it's a portion of the trademark. The trademark is actually Beechcraft. Beechcraft 18 was manufactured from 1937 till 1969. About 9,000 of them were made. They don't make them anymore. All there is left is old planes and parts. And that's what people deal in. And this guy happens to be dealing in a lot of planes. Some of them are actual like Cessnas and Beechcrafts or other Textron products. Or the problem is, he's using it for his email, carl at beach18.com. So he adopted that as his, like it's on his website, his email is there. So there's nothing more to prove. He's using it in a way that is nominative fair use. And I think that Nicholas should stop deciding these kind of cases until he relearns UDRP law, and trademark law. This is
Well, I mean, he
really,
did correctly apply the Oki data factors, right? That the respondents is actually offering the goods, yes. The respondent must use the site to sell only the trademark goods. That's not the case. The site must accurately disclose the respondent's relationship with the trademark owner, maybe. The respondent must not try to corner the market. Um, and that, you know, so you can't find that the respondent's been using it or has legitimate rights to that name. But the bad faith is where I think it really kind of sort of falls apart, especially the registration in bad faith.
So, and you're allowed to, it's not supposed to be just exclusive because we have the Fluke versus Edwin Bryson decision where it allows repair services for multiple brands. Same thing as Sub-Zero versus Adrian Laughlin, approved multi-brand appliance repair service provider. There's no bait and switch. When someone wants something to deal with Beechcraft or whatever, like we'll see in the next decision where it's actually beechcraftparts.com, it's not a bait and switch because they're not going to swap it for some other brand. They have what they have. They're not going to, go for something else.
Yeah, I mean,
I think
I think there's certainly it's a much closer case, and like I said, I probably would have, you know, again, depending on what was in the complaint, I might have just said, look, this is more appropriate for trademark infringement and not the UDRP, and especially because it's been 20 something years. So similar to the Lycoming repair one that I did, you can't just take away the entire business based on this. And so, yeah, I mean, I think this one was may have come out wrong.
I agree with both of
I think there
you.
should be
I
a
do.
class action lawsuit by all these aviation enthusiasts and service providers against Textron. And class action will be a declaration that they're making nominative fair use of their domain names, and that Textron should cease and desist from any further UDRP or lawsuits, and get damages for the people who lost their names.
I can see.
So two different
I mean,
classes of class members.
David, I understand what you're saying there too. So David's saying, yeah, a lot of these people, these companies need to get together because we've went over several cases where this is a company, Textron, that's going after people that own domains 25 years. This isn't like the KFC case. Somebody registered a name 2 months ago selling a meme coin. A lot of these people in the aircraft business, and I agree with Jeff, this guy there was no proof that he registered it in bad faith. He registered it because he had purchased a Beechcraft 18, a Model 18, and there's no proof that he was planning to, infringe. David made a great point of there's cases that show you are allowed to repair other products, other brands, even if you are using, but there's some panelists and some judges really, they'll go back and forth on that. If they think you are doing what David mentioned, a bait and switch, you're using this popular trademark to get traffic, and then you better not persuade them or sell another product, because that is exactly what wouldn't be considered nominative fair use. But there are cases to show if somebody comes in with a product and you're not selling them something new and they have that product, they're going to repair that product, and you only use OEM, say, products to repair it. You can, so it's weird. You can offer repair on other products. But anyway, I'll say this beach18.com was a transfer. The registration 1999, Nick Smith transferred it. So I'm not as mad as David is at Nick. Tempered my agitation with him. I agree with Jeff that this was no evidence of a registration in bad faith 25 years ago, but it was this respondent, and a lot of you listening, you get to see his response. We didn't either. We only see a summary of it. But like I said, the guy was like, "Oh my God, I bought this plane. I only sold it for 80,000. I lost money on it." Well, you had it for 10 years. How much was it 20 years ago? Well, these $200,000, $300,000 planes. I mean, it's like these little aircraft. I don't know. And he's got on his website links to different, looks like movies that maybe he had supplied aircraft for, or they just used them. And he had Amelia Earhart link. I don't know. Did she fly a Model 18? Don't know her history. But the point is, he really then said, not only did I lose money on that, since then I've had terrible luck, and I'm in foreclosure. So the panelist Nick said, "Hey, sorry to hear all this, but I think that you got this name and used it in bad faith." And like Jeff said, okay, but get back to got the name. Did he acquire it? Did he register it in bad faith? Sort of didn't really address that. So yeah, this was, I believe, a bad decision. That's our third transfer for today. We're going to get through our last one pretty quick. This one also very related, beechcraftparts.com. So this is exactly what you would think. Okay, so beechcraftparts.com, the owner would have some fair use rights to it. The complainant is the same complainant, Textron Aviation. This one is versus relative of mine, Todd Huvard, out of North Carolina. No relation. Todd Huvard, or Hubbard, however you want to pronounce it. So the complainant in this case showed that the disputed domain name forwards to aircraftmerchants.com. Okay, and this Mr. Huvard is the president of Aircraft Merchants. So if you go to this domain name, beechcraftparts.com, it still forwards to aircraftmerchants.com, and they offer, services, all sorts of services. Buy a plane, lease a plane, repair a plane, they do all sorts of things. But the complainant claimed this was the classic bait and switch. You're using our mark, Beechcraft Parts. People are going there looking for Beechcraft Parts. You got it going to a more general site that offers, competition to our parts, to our planes, to everything. The complainant, they got, they're getting good at these UDRPs because they're filing so many. And we bring it up because if you have a Beechcraft domain name or a Lycombe domain name, that's the engine, or some of their other products, they aren't dissuaded from going after you if you've owned the name 25 years. Their lawyers are going after pretty much everyone that has a mark in it. And we've seen, I think we saw one out of about 8 or 9 that it was considered fair use and they didn't transfer the name. Maybe 1 or 2, because I'll tell you, there's a lot of great defenses with some of these domain owners against Textron, but yet even sometimes with a good defense, they're losing. So in this case, beechcraftparts.com, the respondent said, "I like this." And Jeff, you can tell me, I guess it doesn't hold any weight. He said, "We registered this name before the UDRP was even established." So doesn't matter, right?
Nope.
Yeah.
Nope.
Okay. So he said, but we also registered it before Textron bought Beechcraft. That doesn't matter either, right? They bought it 15 years before, but it's still, did you register it in bad faith against the previous?
Right, because it's a chain of title, right? So the successors in interest are Textron, and even though they weren't around or didn't own it, they bought all of the IP. So it's as if they owned it way back when.
Right. So in this case, I thought the good defense, and David, you can tell us if you think there was anything defensible here, but I think the best part of the respondent's response was, um, we had a partnership because this guy was mad. This guy owns. He goes. I've used Cessna parts before. That was okay. Now I see that's going to a domain for sale lander. I don't know, but he claimed we had a partnership way back in the day with this company, Woodland Aviation, I believe it was, or Woodland something, to build a website on beechcraftparts.com. We worked on it together. They were a licensed Beechcraft reseller or whatever you call it. And when the .com crash happened, the site, we closed that site down, but I kept the name, and then I just forwarded it to my other aircraftmerchants.com. So I think the good defense there was we didn't register it in bad faith. We registered it partnering with this, licensed reseller. So I thought that was their best chance of keeping the name. But Dr. Beatrice Jarka, who was the solo panelist here, I never heard of her before, she ruled no, she's going to transfer the name. David, what do you think? Good, bad decision? Was there a defense?
Yeah, definitely. It's like nominal fair use, even though they're not using the domain name other than to forward it to their main website for selling different aircraft. And maybe they're selling parts there too. But the key thing here is they're bound by their predecessor in interest. When Raytheon tried to buy the domain name from them in 2007, he quoted a market price, and Raytheon declined, raised no objection regarding ownership. And so you can't go back and say, well, that was my predecessor. I bought the trademark. I'm the owner now. No, you're bound to whatever they did because you bought all the rights that they had. And I don't know if this domain name is being advertised in some directories, because other than that, you're not going to get traffic from an exact match domain like this anymore on Google unless it is actually like a paid link someplace, somewhere, or in some sort of directory. But yeah, I think I haven't fully examined all the possible defenses, but I'm sure this was defensible. And yeah, I think Textron in general should feel the heat and get sued.
Well, look, I think again the difficulty here is in the registration and bad faith. There's another arbitrator that believes there's no difference between registration and use, right? Because they even say, um, when they're describing registration and use in bad faith, the panel notes that respondents' contentions in respect to the impossibility to have registered the domain name in bad faith because Beechcraft was not owned by Textron. That's right. Um, the rights holder in 2000, basically they're saying, well, the the registrant was aware of the trademark, um, and but then it says that then it mixes up. So it says it was aware of it, so awareness, but then it jumps right to use and says, well, they provided no good reason for holding and using the disputed domain name further for the next 25 years. But you don't have to. You have to show that when you registered it not in bad faith, and I think that kind of gets glossed over. Not kind of. It completely gets glossed over, and it's just, well, you're not. We don't think you're using it now in a way it should be used, and therefore you must have registered it in bad faith. Now I don't know if it was used this way the entire 25 years or whether the respondent went into that, but right now it's certainly not being used in a way that would establish any rights on behalf of the registrant. Because, yeah, it's pretty clear that once you go to the site, it's advertising planes for sale, um, mostly that are non Beechcraft.
Well, Jeff, So they did use it differently at the start, and we're going to finish up now. I appreciate everybody being here, but in both of the last two cases, the domain owners did respond. What they needed to do was focus solely on when this domain was registered. Forget everything else. When this domain was registered, here's why it was registered. And of course, in these cases, both respondents can say, we were aware of the mark, of course. We're aware of Beechcraft mark. That's why he got Beech 18. But here's the reason why I got it. Not to target them, to sell it to them. It was because I'm an enthusiast on that particular case. On this second one, Beechcraft Parts, forget how we're using it now. When this name was registered, we, in good faith, had partnered with a licensed reseller to build a website. And what they needed to show was screenshots, former agreements, really just focus on here's why we registered. Of course, we're, like I said, in these cases, familiar with the mark holder. But when you have these cases where you've registered a name a long time ago, but I guess it doesn't matter how long ago it is, if the initial registration was you had reason for it and it wasn't to target and and to take advantage of the mark holders' fame of their mark. In both of these cases, they had some solid defenses and they really answered. They answered the complaints. Most cases, we're talking about here's how I would have done it. Here's how they should have done it because they didn't reply. In these cases, especially the second one, because the guy sounded like he had half of a brain there and he's running a company, he should have said, let's focus solely on when this domain was registered, why we registered it, and provide evidence of why it wasn't in bad faith. And I think they had a solid defense there, but they really needed to focus, like I said, solely on, forget about legitimate use and all that stuff, solely on this. We didn't register this in bad faith, whether or not it's being used as the panel is considered in bad faith now. But okay, well, thanks for joining us. I wanted to make a comment. I saw NamesCon posted something today about a panel that Jeff and I are going to be on. It's a mock hearing that we're going to have at this year's NamesCon, and it's really going to be fun. I'm working on the case facts right now. I'm not going to share it with any of the panelists who, if you want to know some of the panelists, Jason Schaefer is going to be the lawyer for the complainant in the case that we're going to be having a mock hearing over. John Berryhill is going to be the lawyer representing the domain owner. And then we got a couple panelists, Jeff Neuman and Karen Bernstein, and then a surprise third panelist if the guy can make it to the show. I won't tell you who that is. His initials are ZM. Zip my mouth shut. Okay, so because I'd like to have a 3-member panel there. If not, I'm just going to have that third panelist maybe write in his decision, and I'll read it aloud there because I'm just moderating. I'm just the court jester in this. But anyway, check it out. I saw NamesCon announced it, but we're really looking forward to that session. But it's going to be a good time. Might even put on a wig. Okay, so thanks for joining us today. Of course, we'll be here next Tuesday, noon Pacific, 3 p.m. Eastern. That's me, Jeff Neuman, David Michaels. We're your hosts for the Domain Name Law Show. I still do a show with Josh on Thursdays, even though he's traveling, and that's solely about domain investing. So we appreciate you being here. We know domain name law, hey, limited. Some people think it doesn't affect me too much. I don't really care to know much about the legal issues domain investors face, but we appreciate you joining us. If you're more of just a pure domain investor and you want to talk about making money in the space, join us on Thursday. We do that every week as well. That's 10 a.m. Pacific, 1 p.m. Eastern. So hope you can join us on the DNX show in a couple days. Outside of that, everybody have a great rest of your day wherever you're at. Take care.